Okay, now, this is one of the types of the ploys that judges use to tamper juries, to incite hostilities against the litigants of the judge's choice. What should have occurred here is the plaintiff, who is the plaintiff's attorney, if there was something wrong with what I was about to do, they could have objected. I could have then argued, they could have stated their reason, I could have stated my arguments against it, and then the judge, when he made a position, he'd be neutral in this, okay? I wouldn't be arguing with the judge, I'd be arguing with the opposing counsel's opinion of what I'm doing. For instance, if there was something improper about the way I presented it, the opposing counsel has a right to object to that. Do you suppose this judge is going to jump in on my behalf? I don't think so. So what we have here is a method employed by the courts to tamper juries and cause juries to disregard testimony of the litigant of their choice in order to protect the criminal activities that they are protecting and thereby promoting. So anyway, I look over at the jury and I go, oh boy, did I lose that one. You know, I got buried. In other words, I didn't put this together at the time that is what he was doing, but I realized the jury was like glaring at me. So I went back up to the chiropractor and I said, let's see what I have on the desk here. So I go over to my desk and I pull the first document out of a manila envelope that I have sitting on my desk, and I put it in front of the chiropractor and I says, could you identify this? And it was the examination, the true examination, the one out of his trash from the day of the accident. And he says, yeah, this appears to be a medical examination record from my office. I says, and is this in your handwriting? And he goes, well, not all of it. And I said, well, what part is not in your handwriting? And he says, well, where it says Bonnie Sue Nicholson at the top of the document. I says, okay, so your receptionist, when a patient comes in, puts the name of the patient at the top of an examination record, which you then use. He says, yeah. I says, okay, Doc. Now I'd like you to read, what I do is I have the doctor read all the things that I have yellowed in on this document, including the notes. And I say, you know, Doc, you know, I repeatedly, I says, well, this is of the same date as this other examination record you have. He says, yeah. I said, didn't I repeatedly ask you, were there any other documents upon which you recorded any parts of this examination? He said, yeah. And I said, you repeatedly perjured no. And he said, well, apparently I did. I said, well, can you explain to me why we have two different formats here? One's laid out in portrait, one's laid out in landscape. And he says, well, I must have taken some of the exam in another room. I says, you mean you would discontinue an exam, move to another room, and just because you move to another room, you're going to start with a new form? And he went, well, yeah, sometimes. And I says, oh, well, okay. I says, now, Doc, what about all these, how come it appears that the report was taken in pencil, and then portions in the neck area, things relating to what might be a neck area, are in red pen, and then it looks like some of them were changed in blue pen, and then when these readings were apparently transferred to this other document, which you say is the true original, the levels of pain and suffering, as indicated by check marks, and sometimes the range of motions, are worse in this document. And he says, well, you know, sometimes with subsequent testing you find things are worse than you thought they were the first time you tested them. Oh, okay, that kind of explains it. Now, during this time, the judge is like looking over, you know, he's practically falling out of his desk up there, looking at down at what I'm presenting in front of this chiropractor, okay? So I go, well, let's see what else I have here. So I go over to the desk and I pull out another one. And I approach, and I'm about to put it in front of I'm walking toward where the chiropractor is still on the stand. I'm cross-examining the chiropractor. I am presenting relevant impeaching documents, not just any old thing, but things that are going to impeach the testimony he has given. or the documents he has presented. And the judge says, once again acting as plaintiff's attorney, and this needs to be outlawed. With no objection from the opposing party, the judge goes, first show that to the plaintiff's attorney. I says, excuse me, Your Honor, I'm trying to have this document identified by the witness. First, he says, no, first you show it to the opposing attorney. So I take it over there and I show it to the opposing attorney. Now I've never researched as to whether that is a requirement or not, but it would have been Berkowitz's job to object to my procedure if there was an objection to be raised. And then the judge would not be able to employ this to incite my argument against it, to then incite the jury to disregard my testimony and be prejudiced against me. This is repeatedly done throughout the trial. So I put it in front of the plaintiff's attorney's desk, and I don't know what went on behind my back, what kind of hand signals or glances this judge gave this Berkowitz, but it must have been something like, you know, you better do something here, we're in trouble, you know. And so Berkowitz says, well, Your Honor, this document appears to be altered. Judge goes, bailiff, let me see that document. Bailiff takes it up to the judge. Judge takes one look at it and says, this document has been altered and may not be received by the court or seen by the jury. And I says, excuse me, Your Honor, are we talking about the yellow highlighting, which I put on to highlight portions of the documents which are materially impeaching of the same recordations on the document he purports to be the original? And he says, that and other things. I says, and are we talking about the red line that I have put around that document so I wouldn't get it confused with copies, not realizing that when I made copies the red line would be produced? He says, that and other things. I says, Your Honor, he says, Mr. Brayler, the law is evidence which has been altered may not be seen by the jury. Now, this is a fraud and a misrepresentation both to me and to the jury, because the real law, unbeknownst to me at that time, is evidence which has been altered may not be seen by the jury except where the alteration is immaterial, does not conceal anything, does not add anything material, and is easily explained. Even the appellate court upheld that argument. Okay? Although they still said, Mr. Brayler failed to demonstrate that a miscarriage of justice occurred due to the exclusion of these records and his not being able to show the x-rays. So, anyhow, I says, you know, Your Honor, I'm just a plumber, but it's preposterous that there would be a law that says you can remove documents simply because they were altered, because the only alterations on those documents are the alterations made by the chiropractor. And the judge goes, Mr. Brayler, the law is, and he misstates the law again. He says, the law is, evidence which has been altered may not be received by the court, except, and he does not include the second half of the same sentence. It's not a separate sentence. He's only giving us, that there are laws that are even written like that. The law should be written, except where the alterations are material. Then it can be, you know, if the alterations add anything, conceal anything, and are not easily explained, then the evidence should be, that they write it in such a way that you can eliminate half the sentence and misrepresent the entire rule is preposterous. So anyways, he says, by the way, he says, let me see that document that's in front of the jury, the witness. He says, this is also altered, may not be seen. Do you have anything else, Mr. Brayler? I says, well, I do. So I bring out another one of these. He says, show it to the plaintiff's attorney. So I march it by the jury, and I go, here's another one from his trash, completely different from the one that he has, represented as being the true document. And I put it on the guy's desk, and he goes, Your Honor, this also appears to be altered. Judge takes it. So I'm sitting here, I'm stunned. I'm just, where do I go from here?